thundery, overcasty kind of Thursday in Brisbane. It's been like that all week anyway. Enough of such things. I'm Chris Hynes. These days, well, I'll hand over to you, Frank. Frank Higginson, partner.
Oh, no, welcome. Yeah. Hello, everyone. Chris, you can introduce yourself.
So for those of you who have not already noticed, I'm not with Hynes anymore. I've stepped out on my own into the big bad world of individual businesses and consulting, running a strata business called Strata Solve. But as you can obviously tell, I'm here today contracting back to Hynes on different things. One of which is
we're still friends.
Yeah. Yeah, so there's been no fisticuffs in the car park.
No,
not yet. Anyway,
they can come.
Yeah, absolutely. So I'm really happy actually to be back doing the webinar series because frankly I enjoy it. And I know you do too, Frank.
Yes, and I suppose newly appointed Vice President of the SCA for Queensland.
Thank you very much,
announced
Frank.
today.
Yep.
So yeah, no, on the move. A couple of new roles in Chris's life.
But it's the same old strata stuff, isn't it? And that's not to denigrate the strata stuff, but it's the same old stuff. Speaking of same old stuff, we've got a sequel today. Body Corporate Records Part 2. I think it's fair to say, Frank, Body Corporate Records Part 1, that was quite recent, and we had a stack of questions and input on that one, didn't we?
Yep, and I think this is still came from and it still is today. And it was in your time a source of constant inquiry with the Commissioner's office about rights and responsibilities. So again, I think probably if you're lucky enough to be watching this live, great. But if you're watching this at some stage other than on the 21st of October, hopefully this is going to answer a lot of your questions to save you the pain.
Hopefully. And I think it's important, Frank, to go over the reason again why this is such a big deal, why records is such a big deal. And we mentioned it the first time, but let's mention it again. It's because records are the fundamental basis on which anything transacts in a body corporate. If you don't know something or there is something that you are unclear about, the one surefire way, Frank, isn't it, is to obtain the record which tells you the answer.
Absolutely. And they're the corporate history or corporate knowledge, I suppose, of the building itself. So, we've all got our own memories. A body corporate, in a sense, doesn't have memories other than what's in the records, because people come and go, committees come and go, committee members come and go, strata managers certainly do, resident managers do. So over the course of 12, 18 months, a couple of years certainly, you might have a completely new group of people there who do not know what happened 3 or 4 years ago other than anecdotally, so-and-so told me so-and-so, and that's what the records are for. And it is diabolically difficult acting for a body corporate whose records are incomplete. Like we quote on a matter today for something that goes back to a deed that was entered into in 1987. So that already is fraught with danger in terms of trying to get to the bottom of what actually happened. So
that's right. That's right. Before we forget, if you do have questions today, please ask us live and we'll try and get to as many of those as we can. If your question's a bit more involved, we're about to put a link up there where you can put details about that more involved question, and it's probably a far better option for you to put your details into that form. And that will go to the trusty people at Hynes Legal to figure out what to do with it for you. With that, though, we're going to cover off all the things, well, most of the things, or some of the things that we didn't quite get to last time. There's a lot of it. Let's rip right into it then, Frank. First cab off the rank today. Who can obtain a body corporate record? And it's this mysterious thing called an interested person.
Absolutely. So, and that's defined in the legislation itself. And it's lot owners, prospective buyers of lots, I think mortgagees, Chris, lessees / tenants, and I suppose the catch-all is really anyone authorised in writing by an owner to go and have a look. So in a sense, it's almost anyone. And I suppose where one of the things, and we'll dispel this straight up, is the Privacy Act. Everyone quotes Privacy Act with respect to body corporate records and that sort of thing. There is no such thing as privacy when it comes to body corporate records with respect to other owners on its own. There might be some other exceptions, which we'll talk about on the way through this, but your information that is on that body corporate roll is available to every other interested person who's entitled to access it.
Yep.
Email addresses, phone numbers, correspondence you sent in, accusing people of doing whatever it might be. That is all part of the body corporate record and available to anyone who's an interested person.
The legislation then goes on, Frank, to say that an interested person is effectively anybody who can satisfy the committee of a proper interest in the record sought. That opens up a bit of a Pandora's can of worms, that last bit, I think.
You mixed your metaphors there.
Yeah, no, that was deliberate. Yeah, but that opens it up, because what is a proper interest? That's a really great question. Let's pose a couple of hypotheticals then, Frank, to actually get that conversation started. What about real estate agent who wants to do some direct marketing to all the owners in the building, but they don't let any lots in the building?
I'm going to say I'm surprised we don't see more of this. In theory, you know, a proper purpose is a proper purpose. Getting a database from a marketing side of things, probably not. But imagine you're the real estate agent's brother, and you go and get it and give it to them. You're entitled to access it, but I mean, and I suppose then for me, and we might carve this out a little bit in a minute. What is a body corporate entitled to inquire to the greatest possible degree about why you want to access those records?
Well, it would stand to reason, wouldn't it? Because if the committee / body corporate has to satisfy itself with a proper interest, then to determine if there is a proper interest, they have to ask some questions, don't they?
What happens if you? Yeah, they're entitled to. What happens if you get lied to? Could I? No, mate, you're only going to give that to your brother because we know he's been chasing it and he hasn't got it. We've told him no, but we know you're going to do it. Good question. I suppose there you go. There's one for the adjudicators.
Here's an interesting one. So a variation on that first one. What about a body corporate manager who doesn't manage the building, but has heard there are a lot of disputes, a lot of problems in the building, and a lot of unhappy people, and thus wants to contact all owners to let them know about how they can help?
The same thing, really. Is a proper purpose creating marketing solutions, or, well, let's turn this on its head. It's a newly created strata consultancy that knows there's a building with lots of problems, who goes in and wants to find out who's on the committee to contact them to say, you know what, I can actually help you solve those problems.
That's a fantastic question, because on the one hand, it's obviously a commercial interest, but on the other hand, if the outcome, rightly or wrongly, or deliberately or not, is to assist to create a better body corporate.
You're getting closer, aren't you?
Yeah, you are. I still think it's a bit of a dodgy concept, that one, personally. Well, and just finally, while we're on the topic of who can obtain records, so tell us this, Frank, if an interested person has already obtained the records, then they don't get them again, do they?
Absolutely, they do.
They do?
Yep, you can request this as often as you like. I could write in requesting it once a week, in theory, and if I pay the requisite fee, and I suppose the body corporate's satisfied that it's a proper purpose, well, let's do the lot owner who keeps losing the contact details of all of the owners.
Yep.
And wants them again, and then wants them again, and then wants them again. The Act doesn't carve out how many requests you can make of the body corporate to access the records. It certainly does, you know, with respect to motions to the committee now in a period of time and all those sort of things, but it doesn't stop people asking the question.
That's right. What if someone's got a memory problem and actually can't remember they've asked?
Well, that's going to be exactly that, isn't it? Yeah. I'm gradually losing it. So that's both literally and figuratively, I suppose. No, yeah, I think that's it. And that, I suppose, is where you start to have the body corporate maybe reach out and say, can we help you get a little bit more access or understand what it is that you've done, rather than blow up at them requesting it twice. And again, mate, I suppose over the years, that's one of the things you've certainly taught me, is the why. People don't necessarily do all of these things because they're nasty, evil people. It's because they don't actually know what's going on, or there might be some other impediment to them understanding the position.
I think the latter would happen a lot, actually, the impediment one. Let's move on, Frank, to the who decides. So we've established who can ask. So the next natural part of that equation is who decides. So the body corporate manager decides, don't they?
all the time, except they shouldn't be. That's the, you know, and I suppose this is the, one of the things for strata managers is some take a substantial degree of ownership, or you'd say emotional commitment to their buildings. Some are certainly far more hands-off and sit on the fence and just act on instructions. But like all things, like if there is a question to be asked about whether someone has a proper purpose and a decision to be made, that's a decision for the committee, not for the body corporate manager, as much as some of them will do it and stand in the way. And they might know that the committee doesn't want to give access to this person, but they then sit up there and be the punching bag for it. It's not quite the way it works or should work, as much as that's what happens in practice from time to time.
Yeah. So, I mean, the bottom line there is that if you're wanting a record and you get a refusal back, even though you think you're very much of that proper interest and interested person category, it's not the body corporate manager that you've got the issue with. Well, it shouldn't be the body corporate manager that you have the interest with. So there's no point going off your nut at the body corporate manager under those circumstances. Which then I guess leads to the next sort of issue, Frank. So you are an interested person, you have gone through the proper process to ask, and you're still getting a knockback. What do you do then?
Well, that's what the Commissioner's office is for, isn't it? So, you know, and they're certainly busy in there at the moment. And mate, I think, is there a way to, and so I suppose you'd say, you know, a 10-month dispute or 10-month outcome waiting for a decision about whether, you know, a committee spending limit was breached for something that's already been spent. You know, really, that's a theoretical academic exercise. It can wait. It's not urgent. If someone's looking for access to records, it's not, a 10-month wait isn't necessarily appropriate. So I think there are ways to expedite commissioners' applications in relation to these sort of matters, aren't there? And they'll get through the case management a little bit quicker.
Yeah, that's right. So these are the kinds of disputes that usually get expedited. Not always, because sometimes it is quite contentious about whether something is or is not a record and whether someone is or is not entitled to it. But if it's a fairly cut and dried instance of a refusal being given when it should not have been given, then yes, usually that will be sped up. A couple of questions have come through. We might just try and jump on a couple of those before we move on to the next category, because the next category is when can it be properly refused, which I know you can't wait to get to, Frank. But Peter, nice to speak to you again. Is there an overlap between proper and relevant? No, there's not. Well, or is there?
Well, I think you've got to be an interested, so for me, the limbs you've got to tick off. You've got to be an interested person looking for the records for a proper purpose. Tick, tick. If you do both of those things, you're away. I think relevant doesn't necessarily appear in the sense of, and to me, that's a little bit of a subjective thing. What's relevant to you might not necessarily be relevant to anyone else. So, so I think it's back to that proper. So not for marketing, I suppose we've decided today, but to understand what happened 3 years ago in relation to a lift contract, absolutely.
So I think, Peter, the bottom line there is that the committee and the individual need to be thinking of it in terms of proper rather than relevant. There is a subtle difference between the two. Mark, thank you for tuning in. Body corporate has CCTV on common property and records the footage. Members have requested to view the footage as it is a body corporate record. Can body corporate refuse access citing privacy? Well, funny you should ask that, Mark, because one of the sections we're doing today is specifically on CCTV. So we might hold that over until a bit later in this one.
We'll answer that question, won't we? But there's that privacy furphy again.
Yeah. So we will make sure that we answer that one when we get up to the CCTV section. Mark, if you can hang on, and if everyone else can hang on for that matter. Frank, when can the committee refuse a records request?
The prime example you're going to get is in relation to legal professional privilege. So you see a bit of this getting litigated from time to time, and certainly probably the most publicised. I know Christian Porter was a conflict of interest type thing. Skip that. That was going to be an anecdote that doesn't actually apply. No, legal professional privilege applies to, and there's a, whole probably MBAs have been written on this or dissertations. In the shortest possible version, advice given to a client in anticipation of litigation. So if you're going to encapsulate it, it's that. So if body corporate engages us to give advice about a defects claim, we've got an issue with the developer, we're giving them advice about their prospects, about liability of the developer, what they need to do, really importantly, what the weaknesses in their case might be that they need to address, and so on and so forth. That advice is privileged. So the committee can see it, but lot owners can't see it. And they're not entitled to see it, and it's not discoverable to the other side or anything like that. And it's one of the real problems in strata law, because quite often people on committees aren't necessarily all consistent in their views, might not necessarily be of the same belief systems in terms of what's going on, and stuff leaks. So that's certainly not what we're talking about today. But from a records perspective, if we gave an advice to a body corporate of that nature, it is not going to be available to any of the lot owners. End of story. So, and it's a really important part of a committee's role to make sure that they manage that. And it's also really, really important from a body corporate manager's perspective that when advice arrives that is privileged, that it's parked somewhere, either online or in the hard copy records, that isn't going to be available to a search agent.
Lockdown, basically.
Yeah, absolutely. Yeah, password it, whatever it is, because it is not beyond. Like from a lawyer's perspective, if we happen to see something that we know is privileged, we immediately must stop, delete it, remove all records of it, and write back to our counterparty and say, hey, we've seen this. It just appeared, letter, it started with advice. We have not read it. We're letting you know that we've got it, and we're never going to look at it again. But that's not sometimes the behaviour of clients. So it's not beyond opposition to something on body corporate records or opposition to a body corporate to go and scatter in the records and see if they can find that sort of advice. So
it's a hard fought issue in the Commissioner's office, that one, Frank, the privilege issue as well. And that's an example of where there's a dispute about records, but it might not necessarily be a straightforward one because you've got two sides arguing what is and is not privilege. I think I can only emphasize what you've just said there, Frank, the importance of carefully managing privilege, because there are so many risks and consequences associated with that.
And the same thing applies to defamatory material.
Yep.
You know what I mean? The treasurer is being convicted of trust account fraud previously. We don't know why he's here, and that actually turns out to be false. Body corporate can restrict access to that in certain circumstances, and there's probably other ways to handle that as well. If you look at stuff that's not a body corporate record, and we're talking about, say, management rights, management rights agreements, there's a caretaking agreement and a letting agreement that'll be with the body corporate, with the manager, but the manager's letting appointments, so the appointments under which they act as agent for owners as their letting agent, aren't part of the body corporate records. So if I engage the manager and pay them 8%, my engagement's private to me. It's not part of the body corporate.
That's a big misconception, that one, I've got to say. And maybe to sort of wrap up this discussion, when can the committee refuse? When they actually don't have the record. That sounds stupid in one sense, but I've seen plenty of disputes where somebody is an interested person, has proper interest, wants the record, is absolutely convinced that the record is there, but the body corporate literally does not have it. You can't provide something you do not have, not even with an adjudicator's order.
No, there's needle in haystack stuff. And that sometimes happens with records requests, doesn't it? Please give me all of the documentation relating to X. If the body corporate doesn't have any.
And they don't have it. The other thing people do need to think about, Frank, is how literally they take those requests. So a good example of that, and I know that we dealt with a couple of these, you've got somebody who requests a record and they say, I want the blah, blah statements for all of 2024, but they're asking that in 2020. So that's clearly a typo, or is it clearly a typo? Can you push back on that? And the answer is, well, technically you can.
Yeah, this is back to, it becomes incumbent on the person making the request to make sure they've made the right request. So, and then I suppose it's a matter of practicality whether the body corporate helps out in some way or doesn't.
Yep. That's right. And so, but you're quite right, Frank. The individual requesting the records must take responsibility for ensuring they have requested the right record. It's not up to the committee to be making subjective decisions. Well, I don't think so anyway, in that scenario. We are getting many questions coming through. Let's rip into the CCTV discussion, Frank, and then we'll try and, because a few of the questions will be answered here.
Absolutely.
So, CCTV. So really, it depends where the CCTV is installed. That's the issue here. If the CCTV is installed on common property, then a number of adjudicators' orders have found that the footage that's recorded as a result is a record. So that's pretty straightforward, Frank, I think.
Yep.
The
module, I suppose we're going through the Act review process. Maybe it'll be updated to reference footage, but the adjudicators have made it quite clear that if it's particularly on common property, paid for / managed by the body corporate, then what's recorded will be a body corporate record, and there is no such thing as privacy in relation to that. So, and you get a lot of, and so I suppose this is a decision for each body corporate about what they want to do and how they want to do it. And my common response to clients about, but what about if it's recording the pool or the gym or whatever it might be? In a sense, that's no different to me going down to the beach and taking photos or recording people walking around in bikinis and whatever else it might be. Now, that doesn't make it right, but it doesn't make it unlawful either. And so, one of the, I suppose, commentators or I know is watching today is quite, I suppose not quite, suggests to bodies corporate that before they put these things in, they understand how they can be used and how the footage can be kept, which makes sense. But beyond that, if they're in,
that's right. That's right. And yeah, I think that's a really good point, Frank. I know that a number of people would want to install CCTV for a security perspective. Well and good. Okay, that nothing to be argued about. But in this scenario, where the body corporate is installing it on common property, you must turn your mind as a committee to what happens with that material after the event. Because we've got a question here from Anthony. Anthony, it's a good time to answer your question. Can a body corporate refuse access to CCTV footage if the footage requested is a police matter only? No, it can't. No.
It's a body corporate record. The fact that it's been used for a parallel purpose, or the police have requested access to it, and I suppose the police aren't necessarily an interested person under the Act, but you certainly don't want to deny them access. They can. The two things can run parallel, and they do.
Yeah, definitely. So yeah, no privacy. If you've got privacy concerns, you go to the Office of the Information Commissioner and you ask those questions at the agency and see what they've got to say. But I think it will all come back to what we have said today. And then there's the issue about overriding the footage. So usually for CCTV, the footage exists for a certain period of time and then it gets overwritten. Problem that leads you to is that if somebody wants the record, it's not going to be there. It's not going to be recoverable, is it?
And that's probably got a bit better with technology these days and the cloud and all that sort of stuff. Back in the early days, a week later, things were wiped over because you're recording them on discs or whatever they were. So I think for me, one of the really important things for a body corporate that has CCTV is a policy in relation to how they've got to use it. So what's the recording system, how long it's going to last, how owners request access to it. Because the other thing is that, if someone wants, I want to see who was walking around the complex between 2 and 4 because someone stole my bike. Who goes and checks that? Because it's not normally, certainly not the role of the body corporate manager under their administration agreement. 99 times out of 100, it is not going to be the role of the resident manager, if you've got one of those, to review footage as much as it might be to manage the system, manage the recording, send copies to the body corporate manager or whatever. At that stage, it's really up to you. There's the day. Sit there as long as you want, mate. But policy around that and the education is really important.
Which then raises, Frank, a fascinating question of what do you charge for that? Because there is currently no prescribed fee for footage.
Good question. I don't know what the answer to that is. I mean, you go back to the default position, isn't it?
Yeah. So there's been a couple of adjudicators' orders about this sort of stuff. So say, for example, if you're providing a still, so if you can, so you've got some footage which you then convert into still pictures, and they're on A4 pages, you can charge a per page fee for that because you're providing those pages. Otherwise, though, it gets really tricky. There's been an adjudicator's order that I'm aware of where the adjudicator has said it is okay for the body corporate to charge its reasonable costs of access. But that will always be a case-by-case scenario. And this all comes back to the point you and I just made, Frank. If you're going to install CCTV, you need to think about all of these things in advance. It's too late afterwards because you'll be on the spot in that place. And that's not us saying don't install CCTV. No. It's us saying install it, but know what you are doing with it in the process. What about, I mean, like passwords, for example. If you've got like a remote app and it's password controlled and that remote app gives you access to the CCTV, those passwords, and I guess feasibly, Frank, that app is a body corporate record, is it not?
Quite possibly. Could even be a body corporate asset.
Yep. We have got a stack of questions which we will try and clear before we get to our best practice goodies.
Well, mate, I can deal with Peter's there. You know, in the legal, in the professional or legal privilege situation, is a lot owner. Can argue all lot owners are the client? No, mate. So if all the lot owners were the client, we would have a file open in the name of Chris, Frank, Peter, Ross, Mark, Christy, Annie, whatever it might be, and they would collectively be our client. When we're acting for a body corporate, our client's the body corporate for X, and that's the person we report to via the committee.
The legal entity. Yep. Julia, thanks always. I know that you're a regular watcher, Julia. What is the remedy if you are not given the records, just no reply to your email? For example, treasurer asking to receive the bank statement each month. And you've kind of then answered that in the subsequent post, Julia. So you go to the BCCM and wait a year to get the current month's bank statement. Feasibly, you do. Hopefully it wouldn't get to that, but I understand that it might. But yeah, the only remedy for a dispute about an access to records is the Commissioner's office.
Yeah. As unfortunate as that might be for something that is that simple.
Yep. Ross, as always, thanks for tuning in. Can a committee use house rules or a bylaw to limit access under section 205, which is about access to records? Frank?
No. So you cannot contract out of the Act. The Act says that records are available to interested persons. That's it. Can't limit that.
Ross has got a follow-up question. If the caretaker downloads the footage onto a hard drive before overwrite, does it continue as a body corporate record?
Yes.
I would have said yes.
Yeah, and ideally it sits with the body corporate manager so that anyone can access it rather than on the caretakers. And I suppose you'd say a caretaker getting quotes for a body corporate for works to common property, sort of in a sense, those quotes are also body corporate records that should eventually make their way to the body corporate. So CCTV footage in that context is no different to me.
Rebecca, thanks. And thanks for your nice words earlier too, Rebecca. But can the body corporate charge an owner the fee for retrieval of the footage? Yes, possibly. So they charge the prescribed fee for accessing the record. And as we've just talked about, there's no prescribed fee for footage. So can the owner be charged for retrieval of the footage?
And I'd say that the distinction, I think, is for the services provided to the body corporate manager probably is charging. So an owner says, I want this. There's a prescribed fee to get access to that. Then there's the costs of the delivery of access to that information, which the body corporate manager may charge.
Frank's frozen right at the critical moment, everyone. I'm going to continue on in the hope that Frank comes back from being unfrozen any moment now. Ross, another question. Should Chris there be warning? Yep. No, you're back. Oh, no, you're not. Frank's disappeared, everyone. I'll just finish off those questions. So Rebecca, I think what we're looking at there is a scenario where the answer is possibly, but it depends upon the circumstances. That one might require just a little bit more detail, a little bit more thought. Frank is back. Bear with me, everyone. We're almost done, but we should get Frank back on to finish off. Frank, you're back with us.
Boom. Look at that. Technology.
Look at that.
Unreal.
Ross, again, should there be warning signs, and if so, should it disclose that owners may view the footage? Not a bad idea, Ross.
So you'd call that best practice, maybe, but it's certainly not obliged.
Yeah.
So
Frank,
speaking of best practice.
Gosh, we've got a nanosecond to do the best practice side of things. So look, we didn't get to nearly everything that we wanted to cover today. So stay tuned for part 3 of Body Corporate Record. But I guess it's the same as we said last time. Number 1, follow process, whether you're asking for the record or releasing it, because it will all come out in the wash eventually. Second one, Frank, we talk about that, we bang on about this a lot. Legislation is very much slanted in favour of transparency.
Yeah, and so if you're not going to provide something, if not, why not?
Yeah.
What's the basis? But that's a really interesting question if you're going to say no.
Yeah. You don't just say no because you don't like the person. That's not a valid reason. But back to the interested person, we said this before, take a bit of responsibility for your request. Remember that if you're going to ask for 15 years worth of records, then you'll end up paying for that eventually because you contribute levies. Part of the levies go towards the agreement between the body corporate manager and the body corporate. So you will end up paying for the amount of time and disbursements that the body corporate manager has to expend. So be strategic about it. Be strategic. And Rebecca's just going to follow up. The cameras are monitored by an external company and the body corporate pays them when footage is retrieved. I think I go back to the adjudicator's order I was talking about earlier, Rebecca. I am pretty sure that scenario was at issue in that adjudicator's order, where the adjudicator said it was reasonable to charge the costs incurred. Really quickly, Anthony, is the caretaker obliged to hold footage for a prescribed time?
I'd refer to your management rights agreement as to what that says.
What happens if the footage is recorded over?
Well, again, let's go back to the management rights agreement in terms of who's obliged to do what. That's where it starts and finishes.
But if just say for argument's sake, Anthony, it's a police issue, what happens? It's going to have a pretty significant impact if that's a crucial part of the case. But you're right, Frank, go back to the management agreement. We've well and truly reached the end today.
It's all about introducing you as the newbie.
Yes, it was. Look, it's clearly a hot topic, this one, isn't it, the records? So we will do part 3 because we've got a lot more info that we want to cover, but we'll call it there for now. Next week, reviewing bylaws. Basic thing? Maybe not. But
an interesting thing. Yeah, absolutely.
Definitely. It'll be important watching and viewing that one. But for now, Frank, thank you.
Thank you, mate. Well done. Organised, everyone. Thank you for showing up.
Thanks very much, everyone. We'll see everybody next week.
Bye, everyone.
Bye.